Ladies and gentlemen, we find ourselves once more entangled in the enduring mystery of Jack the Ripper. This time, however, it is not merely the speculation of authors or the theories of amateur sleuths that command attention. No, now we hear renewed cries, not from the back rooms of taverns or the pages of some sensationalist pamphlet, but from the public square itself, echoed by journalists and even descendants of the victims. The demand? To bring the Ripper case into a court of law, to obtain a verdict at last, to deliver justice, even across the chasm of more than a century. But how, you may ask? The law is clear. The dead cannot be prosecuted. No living man can be called to answer for crimes long past, nor can civil courts weigh the guilt of those whose estates vanished into dust long ago. And yet, there is one singular legal mechanism, one fragile thread upon which these renewed cries for justice now hang. That mechanism is the reopening of a coroner's inquest, an extraordinary and rare event under English law. If successful, a new inquest could result in an official judicial finding, naming a suspect, confirming new evidence, and declaring, for the first time in legal history, who Jack the Ripper truly was. It would be unprecedented, a verdict rendered not in the heat of 1888, but in the cold light of modern scrutiny. And so the prospect of this inquest has seized the imagination of many, so much so that it has become a rallying cry for some and a source of great profit for others. But let us be clear, this is no simple affair. A coroner's inquest is not a trial. It is not designed to convict, nor to satisfy the appetites of those seeking spectacle. It is a legal examination of the circumstances of a death, with the primary aim of establishing cause. And for such an inquest to be reopened, especially one dating back more than a century, there must be compelling, admissible evidence. Not mere speculation, not recycled theories, but something concrete, something indisputable, something that could withstand the scrutiny of a court of law. And so, the question before us is this: does such evidence exist? The claim that fuels this inquest push hinges upon one alleged discovery, a so-called shawl said to bear the DNA of both victim and killer, a revelation so grand, so astonishing, that if true, it could alter history. But can this shawl stand the test of law, or will it crumble under scrutiny? And if the evidence is as weak as it appears, why then is there such fervour to bring it forward? Is it justice that drives this movement, or something else entirely? Tonight, we shall examine the legal pathways, the evidentiary barriers, and the motives that lurk beneath the surface. We shall separate truth from speculation, justice from spectacle, and law from mere theatrics. But first, let us begin with the broader picture. If a coroner's inquest is indeed the only path to placing Jack the Ripper into a courtroom, then what of all the other legal avenues? Why is it that no other court, criminal or civil, can ever hold a trial for these crimes? Before we examine the only legal path that might bring the Ripper case before a court, let us dispense with all the others, those which, no matter how much one might wish otherwise, are entirely closed under English law. 1. The impossibility of a criminal trial. The first and most obvious question: could Jack the Ripper be prosecuted today? The answer is simple: no. English law does not permit criminal charges against the dead. The Crown Prosecution Service cannot bring an indictment against a man who has been in his grave for over a century. History provides no shortage of macabre attempts to put the dead on trial. Consider Oliver Cromwell, who years after his death was exhumed, posthumously convicted, and subjected to a punishment one would think only the living need fear. But make no mistake, such acts, however dramatic, were political theatre, not genuine legal proceedings. No modern English court would entertain such an absurdity. Thus, the first door, criminal prosecution, is shut permanently. 2. Could there be a civil lawsuit? Perhaps, then, a civil lawsuit? Might the descendants of the victims sue for wrongful death? No. Civil law requires a living defendant, or, at the very least, an estate to sue. Whatever estates the Ripper suspects once held have long since disappeared, and the statute of limitations expired more than a century ago. No court would permit such a claim. So the second door is closed as well. 3. The myth of a defamation trial. What of defamation? Could a living descendant of an accused suspect sue to clear their ancestor's name? Again, no. English law does not recognize defamation of the dead. No matter how scandalous the accusation, the law offers no remedy for those long departed. A descendant could only sue if they could prove that their own reputation had been harmed, a legal hurdle so high that few would dare attempt it. So we may close the third door. 4. The dead end of a public inquiry. Could Parliament or the Home Office launch an official investigation as they have for historical injustices? No. Public inquiries serve modern governance, not historical curiosity. The Ripper case, tragic as it was, does not meet the threshold for government intervention. The state will not expend resources to answer a question that no longer has legal consequences. Another door locked. 5. Could a judicial review force action? What of judicial review? Could a court compel the government to act? Unlikely. At most, it could challenge a refusal to reopen an inquest, but it could not force an inquest to reach a particular conclusion, nor could it compel the naming of a suspect. The law does not exist to settle debates among historians. And so, we have now dispensed with all the impossible roads. There will be no criminal trial, no civil case, no defamation lawsuit, no government inquiry, and no judicial review that might unearth the Ripper's identity. One path remains, one alone, the reopening of a coroner's inquest. It is not a trial, nor a conviction, but it is the only way that Jack the Ripper's name might be uttered in a legal forum once more. And so, let us turn to that final, fragile possibility. Could an inquest truly be reopened? And if so, what evidence might justify it? Having dispensed with every other legal path, we now turn to the only one that remains, the reopening of a coroner's inquest. Unlike a trial, an inquest does not convict. It does not assign guilt. It merely determines how a person met their death. And yet there are those who claim that such an inquest, if granted, would finally unmask Jack the Ripper. But let us be clear, at every step, this process is likely to fail, and those who have been led to believe otherwise, particularly the descendants of Catherine Eddowes, may soon find themselves not with justice but with heartbreak. 1. The legal process for reopening an inquest, a path full of roadblocks. Under Coroners Act 1988, Section 13, an inquest may only be reopened if the Attorney General grants fiat, allowing the case to proceed. The High Court is convinced that new evidence could materially alter the original findings. This is a high bar, and given the public interest in the case, the Attorney General may first demand a preliminary evidentiary hearing to determine whether the new evidence meets even the basic standards required for consideration. If it does not, the request will be denied before it even reaches the High Court. And here is where the effort is likely to fail, because the so-called new evidence does not withstand scrutiny. 2. The Shawl, a claim that falls apart at first glance. This entire push for an inquest rests upon a single item, a piece of fabric claimed to be Catherine Eddowes' shawl, bearing DNA evidence linking her to a suspect. But the leap from an unidentified stain to a proven connection is enormous and legally indefensible. First, there is an inescapable fact that must be stated plainly. There is no evidence whatsoever that Jack the Ripper left seminal fluid at any crime scene. None. Not one single witness, police report, or medical examination from 1888 suggests that any of the victims were sexually assaulted in a manner that would leave such forensic material. Yet, we are now expected to believe that over 135 years later, not only does such evidence exist, but that it has been preserved in a way that allows DNA testing. This is not a legal argument. It is a fantasy. Thus, before we even debate the chain of custody, the contamination risks, or the reliability of the testing, this claim is already without foundation. It is a house built upon air. If the Attorney General demands an evidentiary hearing, this alone may be enough to see the case dismissed before it begins. 3. The likelihood of success, a verdict that will never come. But suppose, for argument's sake, that an inquest is granted. What then? What might a coroner's jury conclude? It is possible, but highly unlikely, that a jury would name a suspect. Inquests do not convict, they rule only on causes of death. The overwhelming likelihood is that a new jury would return the same verdict as before, unlawful killing by persons unknown. Thus, after years of false hope, after intense media attention, after emotions have been inflamed and expectations raised, the outcome will be unchanged, and those who have been led to believe otherwise will be left with nothing but disappointment. 4. The role of emotion, how the press exploits the families of victims. If this case is so weak, why then does the push for an inquest continue? The answer, I fear, lies not in the pursuit of justice, but in the power of emotion, and the media's willingness to exploit it. Descendants of Catherine Eddowes have been thrust into the spotlight, told by journalists and campaigners that justice is within reach, that a breakthrough is at hand. They are paraded before the public, their pain transformed into headlines, their hope converted into profit. And yet, behind the cameras and the interviews, the truth is cruelly simple. This effort will almost certainly fail. For the media, this is a story. For the publishers of sensational books, this is profit. But for the Eddowes family, this is tragedy. They are being led down a path that can only end in heartbreak. 5. If an inquest were granted, who would control the evidence? And here we reach another crucial truth, one which certain individuals might prefer to ignore. If an inquest were reopened, it would not be controlled by the campaigners, nor by the media, nor by those who stand to profit from it. It would belong to the coroner, the jury, and independent forensic experts. Consider the so-called Shawl again. If it were to be tested, it would not be examined by those who claim it as their breakthrough, but by neutral scientists, free from the pressures of book sales and television deals. And if, as expected, those experts found the evidence unreliable, then the very effort to reopen the case may well destroy its own credibility. Thus, the inquest would serve not as a revelation, but as a reckoning, for those who have misled, for those who have profited, and most tragically, for those who have been deceived. 6. The real consequence of this misguided effort. So where does this leave us? Can an inquest be reopened? Yes. Will it solve the mystery? No. Will it bring justice? Unlikely. But will it bring pain to those who have been made to believe otherwise? Most assuredly. The truth is that this case, if pursued, is a tragedy in the making. Those who champion it may soon find that they have not delivered justice, but only false hope and public humiliation. And if the so-called new evidence collapses under scrutiny, if the Attorney General rejects the request, or if the inquest ends with no name, no closure, and no answers, what then? Will those who stirred this fire take responsibility? Or will they move on to the next book, the next interview, the next headline, leaving behind only a broken family and another chapter in the long history of exploitation of Jack the Ripper's victims? This, dear listeners, is the true weight of what is unfolding before us. This is not justice. This is theatre. And the price of this performance will be paid not by those who profit from it, but by those who have placed their trust in it. And that is where we turn next, for this entire effort rests on a single object, the so-called Shawl, a relic whose story is not one of revelation, but of deception. Let us now examine the claims made about this infamous artifact and why they, too, will not stand. And now, dear listeners, we come to the heart of this misguided effort, the so-called Shawl, a single piece of fabric presented as the long-lost key to unmasking Jack the Ripper. It is upon this object that the entire case for reopening an inquest is built. Books have been written about it. Headlines have proclaimed its significance. Some even dare to call it proof. But let us now examine this object as the law would, as a piece of evidence held to the standard required in any serious judicial proceeding. And when we do, we find that the Shawl is not proof. It is not even evidence. It is nothing more than a relic of uncertain origin, wrapped in the language of science but stripped of all forensic reliability. Let us begin with the most damning issue, the Shawl's provenance, or rather its complete lack of one. There is no contemporary police record stating that a shawl was found at the crime scene of Catherine Eddowes. No investigator, no witness, no newspaper account from 1888 mentions its existence. The first known appearance of this shawl in any collection occurs decades later in the possession of a private collector. How, then, are we to believe that this item was plucked from the very ground upon which Catherine Eddowes lay? We are asked to take this claim on faith, faith unsupported by a single documented fact. But courts do not deal in faith, they deal in evidence. And on this front, the Shawl has already failed. If this object cannot be proven to have been at the crime scene, then every subsequent argument, every claim of DNA, every supposed breakthrough collapses entirely. For if we cannot place the Shawl at the scene of the crime, then it is wholly irrelevant to this case. Even if we were to accept, against all reason, that this Shawl originated at the crime scene, we would then be faced with another insurmountable issue: contamination. This Shawl has passed through countless hands over more than 130 years. It has been displayed, handled, stored improperly, exposed to the elements, and contaminated beyond all recognition. Any biological material found upon it cannot, by any standard of forensic science, be considered reliable. And yet, we are now asked to believe that despite all this mishandling, we can still extract usable uncontaminated DNA from it, more than a century after the fact? This is not forensic science, this is wishful thinking. And we must not forget this. There was no record of seminal fluid being found at any Ripper crime scene. The entire claim that such evidence exists is based on nothing but assumption, and if the assumption is false, then the DNA conclusions drawn from it are worthless. 3. The flawed DNA claims, a breakthrough that breaks apart. The next claim, that DNA evidence on the Shawl links Catherine Eddowes to a suspect, is presented as an unshakable revelation. And yet, when we examine the scientific process behind this claim, we find error upon error, flaw upon flaw. The testing conducted on the Shawl used mitochondrial DNA, mtDNA. This type of DNA is not unique to an individual. It is shared by thousands, even tens of thousands of people. It cannot be used to identify a single person with certainty. The analysis that claimed a match to Aaron Kosminski contained errors in its interpretation. When independently reviewed, the supposed match was shown to be far from conclusive. The study supporting the Shawl's authenticity was widely criticized for lacking proper controls, failing to rule out contamination, and using flawed methodologies. In short, even if this Shawl had a provable connection to the crime scene, the DNA evidence it supposedly provides is scientifically meaningless. Would any serious court accept such evidence? Would any coroner's jury stake its credibility on it? The answer is obvious. The Shawl, as evidence, is dead on arrival. The media's role, selling science fiction as fact. And yet, despite these fatal flaws, the Shawl is still being paraded before the public as a breakthrough. Why? Because there is a market for certainty and an industry built upon the myth of Jack the Ripper. The press does not report doubt. Doubt does not sell newspapers. Caution does not fill bookshelves. Skepticism does not make for thrilling documentaries. And so, what should have been discarded as an unreliable artifact has instead been repackaged, not as a piece of forensic detritus, but as the long-sought key to solving the greatest mystery in criminal history. And in the midst of this circus, where are Catherine Eddowes' descendants? They are led to believe that at last their ancestor's murderer will be named. They are placed before cameras, their grief turned into spectacle. And when this effort inevitably collapses, when the inquest is denied, or when the Shawl is dismissed in court as inadmissible, who will stand to answer for the pain that has been inflicted upon them? Will the authors retract their claims? Will the journalists admit their part in stoking false hope? Or will they simply move on, leaving the Eddowes family to pick up the pieces? 5. The Shawl is not evidence, it is a distraction. And so, dear listeners, we see the truth laid bare. The Shawl is not a breakthrough. It is not forensic gold. It is not even legally admissible evidence. It is a distraction, one that has already done more harm than good. The coroner's inquest will not be reopened on the basis of an object with no provenance, no credibility, and no forensic reliability. The case for the Shawl was over before it began. And so, we must ask once more, if the evidence is so weak, then why is this effort being pursued? What is truly being sought, justice or attention? And if justice is not truly the goal, then we must confront the final question. Who truly benefits from this renewed pursuit of Jack the Ripper? To that, dear listeners, we shall turn next. For if the case cannot be tried in a court of law, then it must be tried in the court of public opinion, and the motives behind this effort must now come under scrutiny. And so, dear listeners, we arrive at the inevitable conclusion. The case for reopening a coroner's inquest is built on a foundation of sand. The evidence, if it may even be called that, fails at every level. It has no provenance. It is irredeemably contaminated, and its so-called DNA breakthrough is neither legally admissible nor scientifically reliable. Even if an inquest were granted, it would almost certainly result in the same verdict as before: unlawful killing by persons unknown. So why then are we here? Why are we speaking of courts and inquests, of DNA and justice? Why, after 135 years, are Catherine Eddowes' descendants being led to believe that an answer is within reach? 1. Justice or theatre? The true motivation behind this inquest push. To answer this, we must first ask, who benefits? Do the victims' families benefit? No. For them, this is merely the prolonging of grief, the raising of false hope, the promise of justice that will never come. They are being used, not as participants in truth-seeking, but as props in a spectacle. Does the law benefit? No. A failed inquest would not strengthen justice. It would diminish it. It would set a dangerous precedent that history, rather than evidence, may dictate legal proceedings. The courtroom is not a place for storytelling. It is a place for facts, and facts do not support this case. But there are those who do benefit: the authors who publish books promising final answers, the filmmakers who sell documentaries that claim breakthroughs where none exist, the journalists who print headlines designed to excite, not to inform. For them, this is not about justice, it is about profit. 2. The tragedy of the Eddowes family: false hope and inevitable disappointment. The greatest tragedy of all is that this has been done before. Again and again, the case of Jack the Ripper has been solved, in books, in articles, in television programs. And yet here we are, no closer to the truth. The cycle repeats, the names change, but the result is always the same. No resolution, no justice, no closure. And in the midst of it all, the Eddowes family now finds itself caught in a web of sensationalism. What will they be told when this effort fails? When the inquest is denied? When the so-called evidence is dismissed? Will the press return to report on their heartbreak? Or will the cameras move on to the next manufactured mystery, leaving behind only disappointment? They have been promised justice, but they will be given only silence. The final word. The case that will never be solved in a court of law. And so we return to the truth, the one that remains, no matter how much some may wish it otherwise. Jack the Ripper will never stand trial. His identity will never be confirmed in a court of law. The inquest, if pursued, will either be dismissed before it begins or will end in frustration for those who believed it would bring answers. This is not a failure of justice. It is simply the reality of time. The Whitechapel murders belong not to the courts, but to history, and history does not try cases, it only remembers them. Justice, real justice, does not come from chasing ghosts. It does not come from twisting the law into something it was never meant to be. It comes from honesty, from recognizing that there are limits to what can be known, from understanding that there are wounds which, though they may never be fully healed, must not be reopened for spectacle's sake. For those who claim to seek justice for Catherine Eddowes, let them ask themselves this: are they seeking truth, or simply another story to tell? And let history judge the answer.